Good evening, and welcome to AUP. For those of you who are visiting us this evening, and that includes two of our panelists, we're delighted to have you here. And for our students, our faculty, and our former students, it's a delight to see you. We're here to celebrate a book, Modeling Justice. I read this book when it was a doctoral thesis. I was actually I'd say a proofreader, if you will, for this book. And to see it now in print is a joy. I'm really delighted. Kerstin Carlson is a colleague of many years. She teaches at AUP, a summer course. She teaches also at the University of Southern Denmark, where she's a leader also at the War Studies Center. Her specialization is law and society, more particularly transitional justice. She is working on two books, and I'm going to check my notes, two future books. The first is the Justice Lab with Chatham House, and the second is her Habre book with Sharon Weill for Oxford University Press. So this book was really a path-breaking book for Kerstin. It's gotten her name out in the international justice community, and we're extremely excited to welcome her here this evening to speak about her book. And I will then introduce our discussants. Each one of them will speak about 10 minutes and provide you with their analysis of her work. So please join me in welcoming them all to AUP.
Thanks so much, everyone. It's really a pleasure to be here. Thank you very much to my panel for being here, for taking the time to read the book, comment on the book, and have this discussion with you guys. So in thinking about how we would take this hour and a half, so we'll talk for about an hour and then try and give some time for people to ask questions, I was trying to think about what I could say about the book to sort of tell you kind of the Cliff Notes version. Right now, it's like you know the book, you've read the book. How I could make use of this stellar panel, right, of people who are experts. Now I've asked them to read my book, so how we could engage with them. But I also wanted to speak a little bit about process, because I took about 13 years to finish this dissertation, took another 5 years to turn that dissertation into a book, depending on how you count them. And I think one of the things I learned in that process is that I feel like people don't talk about process very much, and I felt a lot of times like surely no one was a greater failure than I. So I thought that one of the things that's important to do is to say how it is that it's hard, where it's hard, and what you do when it's hard, so how you sort of reach out. So that's our plan for today. So the book started when I was in law school. I was in law school a very long time ago now. And it was the heady 1990s, and we'd made these ad hoc tribunals, right? Liberalism had won, the Cold War was over, everything was going great, we were right, they were wrong. And then there was violence in the world, and part of what transitional justice tells us is we can fix violence with law. That's awesome, so let's do it. So we had the breakup of Yugoslavia. That was the first instance of genocide in Europe since the Second World War. And the idea was, well, we'll just add law. Surely if these people had better law, they wouldn't be so violent, so we'll make a court. That was the International Criminal Tribunal for the former Yugoslavia. It's kind of a fascinating experiment because it was set up by the UN Security Council in 1993 while the war was still raging. And when the war ended in 1995, they still hadn't tried anybody, right? They had one guy that the Germans had picked up. But really not much was going on. So it would have been easy enough to close the whole thing down and say, okay, we set this court up to get peace, we have peace, we're done. But they didn't. They said, no, we're gonna go ahead. We have an example from Nuremberg that's a powerful example, and we're gonna test it out. And right after that, Rwanda happened, and then we also set up the ICTY. So I set out, and then while I was in law school, the International Criminal Court happened. And that's also kind of extraordinary. In 1998, the Rome Statute was signed, and it was on the backs of these ideas. And then 4 years later, there was a court, and it was unbelievably fast. It was really extraordinary. So I, like a good transitional justice scholar, I'd gone to Bosnia in 1999 as a law student. I was a researcher. I'd had a frustrating time because I went to ask questions about how much do you like the ICTY, and the answers should be a lot. It's really fantastic, or my God, thank you for coming to fix everything. And since I had studied Russian in college and could read Cyrillic, I was with the Bosnian Serbs. They did not like the ICTY. They were not so thankful that the internationals were taking this kind of interest with them. And when I came home and I sort of presented this to the people I was working with in the Human Rights Center, they were like, but that you shouldn't have found that out. That's not what we want to do. Like, that's what the Serbs need to do, is they need to apologize. That's certainly true. Like, if the Serbs were ready to apologize, everything would be fine. But I didn't find that out, and I think that's something that Sharon's going to talk about, right? I went into the field, I asked questions, I found data, the data do not indicate. And in fact, if we write something about how bad they are and that they should apologize, then they'll really feel victimized. Like, they already feel pretty victimized, but then they'll have kind of a reason to feel victimized, and I don't want to be part of that. And so then I had a bit of a problem. So then I found a PhD, basically. I found a professor who was willing to work with me, and I started working towards my PhD. And so that was okay, lawyers don't want to deal with this way, but academics will, right? And so that is how I sort of moved towards law and society. Then I went back to the Balkans, and I had this clear transitional justice project I wanted to see. I studied Serbo-Croatian, I learned it, so then I was going to see how much the court was affecting reconciliations. That was my research question. How has the ICTY impacted reconciliation? And when the good clue that I've learned over the years, you don't ask, is it? Because then you get a yes or no. You ask how questions, right? So how? But then I found all these really inconclusive, problematic answers that different people in different places, depending on what had just been decided, for whom in their ethnic group had very different ideas about the efficacy of the court, the popularity of the court. So then I had a problem, right? So I couldn't solve the problem, but I wrote a PhD. And what I did with my PhD was, so I'd sort of I'd spent all these years in the field, and I decided, well, I can actually theorize transitional justice. One of the problems with transitional justice is that you either believe in it or you don't. There's not a lot of empirics. So maybe if we thought about what it is as an ideal type, that would help. And that's the first part that's really what my PhD is, and that's the first argument in the book. That's the first chapter of the book. The first chapter of the book says, all right, Nuremberg, the experiment in Nuremberg was an experiment in international criminal justice, and the question is, why do we use it? What's it supposed to do? And this is my theory, that international criminal justice is supposed to do three things. It should articulate progressive international criminal law, it should establish historical fact, and it should reconcile warring groups. And those are the three things it should do. And you'll notice that I put the progressive in bold letters, because the more I thought about it, the more I thought it's this idea of progressive international law, right, that's so important. But that's really problematic, because one of the things that's happening then is that, this happened already at Nuremberg, we just declare new rules, right? So we take a bunch of things that have happened in the Second World War, and we say the law as we have it right now doesn't really cover this, but this seems really bad. Everyone can agree that this is bad. We don't want this. So this becomes crimes against humanity, right? And following Nuremberg, we had the articulation of genocide, right? But crimes against humanity hadn't been articulated yet when people were found guilty of it at Nuremberg. And that is a violation of the legality principle. As lawyers, we think it's very important that we say what the law is first, and then we apply it to people. So one of the problems that we had with international criminal law was it was seeking to create a better world, and it was saying that one of the things it was doing to do this was articulating progressive international law, but that very articulation was illiberal. It was not progressive, right? It was a violation of the legality principle. So this troubled me in my dissertation. I didn't really know what to do with it. I needed to finish it, so I had my transitional justice idea, and I just said, and by the way, there's different interest groups here. Like, some people want this, so the international lawyers are happy, and then the people on the ground aren't happy, and so that's what's happening here. It's kind of a mess. So that one of these things we can do when we think about the ideal type is we could ask questions when we compare different audiences under this. And I left it at that, and they awarded me the doctorate. Thank you very much. But this was really, this idea of the violation of the legality principle, the problem of progressive international law, is I think really my addition to the state of the art with the book. This is what I think is theoretically important in the book. So here, I say that the law's legitimacy is built on the legality principle. You've heard it. You can only apply rules going forward. So you can't have ex post facto rulemaking. And it's this progress narrative that gives international criminal law its legitimacy since Nuremberg. And what I called it, and this was another great piece of advice I got when I did my postdoc, was I called this one of my boss at my postdoc said, if you're going to have a hard to understand theory, try and give it a cute little name, right? Try and find a way, so that's like the thing that you do, right? So that everyone can understand this kind of stuff. So I called it the problem of non-derogation. And you can tell me if this is cute enough for you. But the problem of non-derogation is that we say at international criminal law, you can't derogate. You cannot step away from the idea that's been articulated. There's no contextualization, right? If something is illegal, you're a camp guard, and you've done something illegal, you're helping what we call enterprise which is itself illegal, then that thing you've done is illegal. We don't ask, well, how did you get to be a guard? We don't say, oh, do we feel a little bit bad for you? Maybe you were young, et cetera. We think about those things when we sentence you, and here my lawyers on the panel can tell me if I'm very, we take that mitigation into consideration later, but it doesn't change the nature of the crime itself. And this is really distinctive at international law, because those of you who look at human rights law will maybe be familiar with the margin of appreciation, which is how human rights law usually works. So you have a human rights court. The most advanced one is here in Europe. I would say the most advanced. It's the biggest. It's been working the longest. It has the most jurisprudence. So it's the most successful in that sense. And what that court does is it tells states when they violated the human rights of their subjects, but it has a margin of appreciation that says different states can make different rules about what freedom of speech is, right? Or how much you need to, how big a zone of privacy is. That might look different in Greece than it does in Hungary. And that's fine, so long as both those countries have a good faith attempt to respect whatever it is that we've recognized as a right. But you don't have that in international criminal law. There's a rigidity to international criminal law, which in a sense is baked in. Its legitimacy comes from its insistence that it will be rigid, that it will not contextualize. And that means that what it wants to do, it wants to be progressive, and those other things that were part of the transitional justice template, or the international criminal justice template, as I call it, those things can't happen. Because if some institution is telling you, here's the history, we figured it out, but you see that they've applied something that looks like it violates a notion of justice, it's going to be harder to accept. Right? So then what I did, after I sort of working through this, I wrote an article, a short article, I worked out my cute problem of non-derogation, and then I sort of shored up all of the pieces of the pieces of the dissertation I'd already written to marshal chapters that would demonstrate that. So in essence, this international criminal justice template, the 3 things I say international criminal justice does, all of those things are rendered impossible by this problem of non-derogation. And then I take cases from the ICTY, which I spent all of these 13 years studying and reading and following, and I show how that works. And my favorite one is this case of this prison guard Kwochka, who was one of the early prison guard cases. He got 7 years. He was, I think, 20 days. He was in one of the first prison camps. He was a policeman. So he was just told to show up one morning. And it turns up he opened up a concentration camp, essentially, one of the first concentration camps following the Second World War. He was married to a Bosnian Muslim. He obeyed the rules. So people would come in, he would take their notes, right? He would take notes about them. Then he would go home at the end of the night. He would come back. There would be dead bodies. He would tell his superiors, like, people have been killed at night. He would write reports, right? When other thugs, because everything was breaking down, so people would show up, everyone was armed, and people would show up in the camp, just they would come in and start, at one point, there was one day an incident where people started shooting. He put his body between these random people showing up and shooting and the prisoners, right? So he did a number of things that were truly exceptional. He also, as a policeman for what was now the Republika Srpska state, the Serbian state, he made possible a concentration camp, right? So, but what I think is interesting about the Kwochka case is when you look at the doctrine behind it, the doctrine had to do with his intent. And they said, listen, he knew bad things were happening. And his knowledge that bad things were happening is the same as intent. And this was under joint criminal enterprise, and we can talk about it later if you have questions. There's a whole chapter about it in the book. And it's a pretty interesting doctrine. It's been rejected by the International Criminal Court, but no one has a better solution. Really, joint criminal enterprise is the question of how do we get a bunch of people about whom we don't have a lot of facts, how do we find them guilty, right? It's a legal problem, it's a dilemma, and it's a shortcut to solve this dilemma. But in the case of joint criminal enterprise, as I show in the book, what we did to Kwochka, where we said you knew, therefore you intended, it's legally the same. When we went up the chain, which was supposed to be the idea, we stopped doing that. Because all of a sudden we had commanders and we said, well, did you know that the arms you were funneling from Serbia were going to the paramilitaries? Did you intend exactly that? Because part of what you were fighting was a legitimate war. So if you didn't intend that, then you're not guilty. So we've actually changed the doctrine, or the court has changed the doctrine in its 20 years of practice. Right? And this, again, I think, is part of the problem of the making the progressive law up as you go along. So you're going to need some flexibility, but you end up getting into trouble. So last, because now I've probably spoken too long, I wanted to think, and this is what I asked people to think about here, what has my book done in the world? And so I want to, in a sense, provocatively suggest that I predicted what happened with the Bemba. Yes, my book predicts the acquittal of Bemba. Because recently at the ICC, there was a high-level acquittal of a car general, but someone who'd been fighting in Congo, and it was 3-2, and it basically went down along these lines of doctrine. This was a guy who people have been very excited because it was the first conviction for sexual violence, a very important issue that's been under-addressed in international criminal law through the ages. He was convicted in the trial court level of being a general whose troops committed acts of sexual violence. And he was acquitted at the appeals level because 3 of the judges said, you can't tell us what he's supposed to do to prevent sexual violence, right? When he heard there were incidents, he put people on trial, he did things. Was that enough? Was that not enough? What's the standard? And so I suggest that this is the problem. This is our problem of non-derogation. We don't actually know what the standard is. And what was happening in the Bemba appeal and his acquittal was the judges of the ICC were insisting we need to have stricter notions of what law is. Anyway, thanks very much for listening, and I turn it over.
We're going to leave your predictive slide up on the screen. I'd like to now introduce Sharon Weill. Professor Weill, for many of you, have her as your professor this semester. She joined our department several years ago, and she is a specialist in law and also in transitional justice, law and society and transitional justice. One of the most remarkable things about Sharon is that in addition to serving at AUP as a professor and a mentor to students, she publishes extensively, and she's a member of the French Human Rights Commission, and recently has taken on a nomination, I believe it was, to work as a judge for migrants. So she is a remarkably prolific member of the French intellectual scholarly community, legal scholarly community, and it's a pleasure to have her with us this evening to comment on her good friend's book. So thank you very much.
Thank you, Susan, for your kind words. So actually, I'm really happy to be here with you and with all the panel. And actually, the first time that I met Kerstin, so it was in Berkeley, where she did her PhD, and she presented the result of her PhD. It was in 2015, January. I did her my postdoc, so this is how we met. I heard her presentation, and then immediately I approached her, and then I discovered that she was in Paris, and if you remember, it was the day there was a terror attack here in Paris. Yes, so it was a very unique day. Anyway, so from then on, I think our collaboration really started and continued until today. And by the way, this is how I reach AUP, because you find your position, another position in Denmark, and then I came here. And so what I want to speak today about is about the special approach that Kerstin has as a matter of method. So here we heard about the finding, but I want to point at the. Is it okay? It's fine. Yeah. Okay. Sorry. I want to point at the method that she did during her PhD, and a method that we continue together in the upcoming book that we are going to do. So the question is, how do you research trial? How do you research legal institution? How do you research justice? So when you will go to most law faculties, usually the researcher will read the court decision, will look at the doctrine and the framework, and then we will react on this at theoretical level, at doctrinal level. But it wasn't enough, nor for Kerstin, nor for me. And in a way, even though that we came from the law department, we started to look around. So first of all, you need to look around at political science, because you need to understand the politics of international law. You need to understand the special circumstances that brings one case to be prosecuted and another not to be prosecuted. So the politics is very interesting, very important. But it's not all. What is the contribution of Kerstin in her research is the fact that the accent that she puts on the actors going on the field and doing interviews. Because you can't learn the ICC without never going there, without open the door of the court, going inside and see how it works. Because this is something to have doctrine, this is something to have the politics of the court, but then it's another thing to see how the court is actually working, who really do the work, what is about this routine, about the banality of the court. And I think that I at least learned a lot from you when we did our research on the Habre trial, because this was really the approach that we took in this project that we did together. So just to explain, the Habre was the president of Chad. He committed atrocity during his presidency, and he was prosecuted for crimes against humanity and torture in 2016 in Senegal, in another African country. So we went there to understand what happened in this trial. So Kerstin started this research before. She followed also some of the trial, I think. We went there on the appeal. But most importantly, we interviewed the people to understand how it really worked. So the idea was to interview a whole range of actors. So of course, we will interview the judge, the prosecutor, the defense lawyer. This is all obvious. But we opened the door also to less obvious persons. For example, we went to see the bâtonnier. The bâtonnier, I don't know how to translate it. The bar, exactly, the Bar Association of Senegal, to understand. And then we discover they have only 500 lawyers in Senegal, you know? And there are like tons of law students there, you know. So then you start to uncover things that may be irrelevant, but then you understand the relevancy. Then you understand how the defense lawyers were nominated, for example. We went to see, of course, journalists. We went to see media activists, local NGO, the donors. So we went to see the Swiss embassy, the French. Then we understood the problems that were between the donor and the one that were controlling the money within the court. So anyway, all this to say that it's by going to the field and asking questions that seems to be not relevant, that then you can understand the entire picture. And then when we come back from our interview, we said, what are we going to do? And then we decided the best thing will be that we let those actors speak for themselves. So what we basically do, we've taken 26 actors, different actors, what I've just said, and we asked them to write for us a chapter in the book. So we ended up by editing like 40 chapters. I cannot tell you what, it was a crazy work, but this was we did. And in this way, we introduced a new methodology, at least in the law discipline, on how to study trials and how to study court. So we have one introduction of all these different actors, their input in a direct manner. And then in the second part of the book, we have academics commenting on this. And we have also Sara, who contributed an excellent chapter. So it's a double pleasure to have her here. Okay, so all this, I'm not here to speak about this book, but I'm here to speak about this method that for sure was for this book, because you say it took you 20 years, but she was not reading 20 years the ICTY decision. She went there many times, she did many interviews, and I think, and this is also what I told you when I read the book, when you read one sentence of Kerstin's book, you know that this sentence could be written only after 10 years of research. So, no, because, you know, there is one sentence that you can just write. But there are those sentences that are so condensed and with so much finesse and insight that this is only because you master really your subject. So this is what I feel about this book, and it was a real pleasure to read it. So maybe just a word, so I won't speak too much more, a word about the difficulties. So about the Habre, what was interesting, it was very, very easy to have access to the actors. we met the prime minister, the former prime minister, by one email, you know? It was like we have a really, really easy access to the actors. This is sometimes that you don't have in all the field research, but at least there it was the case. But then what is become hard when you do this is that you hear so many things and so many things that you cannot tell because they tell you out of the record. And then this is really, for us, it wasn't easy always how to manage this information. Because of course you are here as a researcher, you are not here as a gossip of the court, right? So you need to be able to terrorize what they are telling you. But then if not, so this is one thing that is a bit lost concerning this method. And also, of course, always when you meet a person and you have, even now that he have translated the meeting through a book chapter, you lose something in translation, of course, when you speak or when you write, but this is a way that we did this. Voilà, so thank you for this opportunity to present the book here and for the students, and I hope for future collaboration in Colombia, by the way. Huh? This is the next project.
Thank you, Professor Weill. I now have the pleasure of introducing Sara Dezalay, who is a first-time visitor to AUP. She is a senior lecturer at the Cardiff School of Law and Politics in Wales, but she also is a senior researcher at the Monk School of Global Affairs at the University of Toronto and a visiting fellow at King's College London. Sara's background is in international law and international relations, and her work focuses primarily on the role of law and lawyers in global governance. She researches two main themes: transitional judicial responses to conflict, which is of interest to me, and also the evolution of the position of Africa in legal globalization. And in this last aspect of her work, she's espoused a deliberate field-building strategy to dispel ideological visions of the African continent as a lawless realm by building knowledge on legal elites and legal professions across sub-Saharan Africa from the colonial era to the contemporary phase of globalization. That's particularly important, and you may be one of the rare people globally who is doing that. So I think there may be others, but I'm impressed. I'm impressed. So I'd like you, there's much more I can say about Sara, but it's an honor to have her here with us this evening, and I'd like you to join me in welcoming her.
So it's a great pleasure and to be here to celebrate your book, Kerstin. I can't even remember when I met you. I think it was through Ron Levy years ago, and then, well, anyway. So it's a great pleasure to be here today and to have the opportunity to discuss your book with such a great audience. What I like to do in hopefully my short intervention, but please stop me if I'm too long, is to react and respond to two dimensions that have particularly struck me in Kerstin's work. The first is what you underlined as your main substantive argument, the paradox of illiberal practice in pursuit of rule of law liberalism that she sees at play in the operations of the ICTY in particular and international criminal tribunals in general. Broadly speaking, the way I will respond to that argument is to relate it to the relationship between law and politics. The second is in a way more ambiguous, even though it may have struck you as evident in how she presented her book and in her presentation, but in her book as well, as it relates both to her substantive claim and her position within the field. It is a claim that runs throughout her book, that her critique is positioned within liberal legalism, and that her intervention is aimed at perfecting international criminal law, not eliminating it. I'll explain why I found that ambiguous and how I respond to it. To respond to these two main points, I have identified four interrelated themes, which I will offer to you as black boxes to open and ponder on. There's first of all the question of distance between law and politics. Secondly, the question of legacy, that of Nuremberg, and more generally, that of international criminal justice processes. Thirdly, there's the question of international criminal justice as a form of external intervention. And fourthly, there's the question of critique. How can we position our critique of international criminal justice? I'll start with the fourth one, because I see it as very much driving the other three. Now, before I speak, I have to show my hand and tell you where I speak from, as it shapes deeply my intervention as a scholar and how I will unpack each of these themes to you. I'm a political sociologist, much informed by Bourdieuian sociology, so it sounds like a lot of words, but this basically means that I am less interested in the substantive content of the law, but more interested in its material component. That is how law is connected to and shapes power relations over time. This meant that I felt very much like Alice looking through the looking glass when I read Kerstin, through her exquisitely informed analysis of the ICTY's case law. She became, for me, Kafka's Before the Law's gatekeeper. I don't know if you know that wonderful parable of a man who seeks to enter a courtroom, and he stumbles on a gatekeeper who tells him, you cannot enter. But you may try. But if you try, you'll find out that I'm the first of at least 40 gatekeepers. So for me, that was that. Okay? But this parable, as I'll explain a little bit further later on, this parable is very much about the relationship between law and politics. Well, I'll unpack this. So basically, she showed us in detail how the ICTY operates within a hermetically sealed textual universe that is also, but this is where the ambiguity lies, ideologically shaped. And this is what makes her argument about the discrepancy between illiberal processes and liberal claims so powerful. But reading her, I also kept asking myself, why is it that scholars, but also practitioners, interested in international criminal justice, and particularly the ICC right now, always seem to need to justify their position? They always seem to need to say, I am for the ICC, or I am for international criminal tribunals, or I am against the process. This is what I call the critique, or the problem of the critique, or positioning oneself. In my work, I chose sociology as an epistemological stance, one that enables me to look at the fray from the outside, to not ask how processes could be made better, but how those processes take shape in a way. In the immediate term, this limits the policy impact of my intervention. After all I can say is it's complicated. But it is a way of at least building distance in reflexivity, in a way, in how I try to build knowledge. Now, I said that I had the sociological take on why there is such an acute divide in scholarly and policy position takings on international criminal justice. And I think it is deeply related to the three other themes that I want to unpack briefly with you. The first is the question of the relationship between law and politics. You may be aware of a book that was recently published by Philip Clark called Distant Justice. And in a way, it epitomizes the state of the debate in the field. My point here is not a criticism, but it's rather to show how political sociology can add on to the debate. And specifically, Kerstin's way of situating the ICTY in relation to national context, or the way you do it in your Abré book. There is, and maybe it's something that you've stumbled on in your studies or research or work, there is an ingrained incapacity of law and political science to dialogue. It's particularly clear in France for multiple reasons, but there is a reciprocal blindness between the two disciplines. For lawyers, politics is always a problem. For political scientists and politics generally, law is not a problem, it just doesn't exist. It's a black box, and it just doesn't bear opening. So you get political scientists who are blinded completely by law, like they're as if it was meeting the sun, or others just ignore it completely. And I had the chance to interview Ocampo some years ago. So he was the first prosecutor of the ICC, and he had just stepped down with Ron Levy, a longtime colleague. And he had this very telling formula. For us, international law is law. But for others, it's just politics by other means. So of course, it seems evident, especially when we look at the ICC and we see that court as being constantly vulnerable to constant coups, that is, constant pushes and shoves by states and others to break it in a way. Yet, this formula also invites us to make a specific effort to understand and unpack carefully the relationship between law and politics. Otherwise, the risk is to be ensnared and trapped in ideological representations. Of course, this relationship is made especially complex in the case of international criminal tribunals, because they're bizarre forms of tribunals, because they're international, because they're just plain bizarre, right? But there are three levels where we could unpack that relationship. There's the relationship between law as substance and politics as action, the relationship between institutions, and specifically ICTs as international institutions and politics, and what they produce as institutions. And there's a relationship between lawyers, that is the agents of international criminal justice, and politics. I'll try to be brief here, but there are three dimensions that can encapsulate this relationship, this three-level relationship between law and politics. The first can be summarized in the formula that you've probably all heard in your life: the king is dead, long live the king. This formula and what it entailed in the work of law and lawyers to legitimize power has long been established since the work of Ernst Kantorowicz. It basically says that law is politics, and politics is about law. Law is there to bring legitimacy to politics, but it also means that within law itself is this tension to build autonomy from politics, to be able to build symbolic power. So you have in law itself this ingrained push and pull between being embedded in politics and trying to gain autonomy from politics. The second component is what we, when I say we, it was like a very small me and two big others called Ron Levy and John Hagen, called complex political environments, to try to understand where the ICTY and after the ICC were positioned, were operating. This idea that they were operating in environments that were rendered complex because there was an intermingling between national and international components that rendered the law and politics relationship even more complicated. The third component is an effort to be made to open the Pandora box of what we call the international. Kerstin does it in her book, in her research, by saying, well, we have this aspect of the court, but then if we go to the local level, how do they perceive the international? In a way, this effort to open the Pandora box of the international is a way to respond to calls to de-Europeanize international criminal law. There's been calls in global history, for instance, to show how some courts bear the trails of imperial paths, like the European Court, the East African Court of Justice, which is built within the path drawn by the imperial system and the imperial system of the rule of law within the British Empire. So basically looking at those paths can help us understand how the international is embedded in the national and vice versa. This brings me to the second related theme, and please stop me, yeah.
Maybe just one more thing.
Yeah, so two very brief points. The second related theme was legacy. My main critique to Kerstin, and this could be a question, is that I see the legacy with Nuremberg. I see it conceptually. I don't necessarily see it sociologically. And this critique applies to where we draw the strings from Nuremberg onwards and how wide we should expand the focus on where the legacy lies originally and what the tribunal has built contextually. In particular, I was thinking of the work of Vaucher and others who have focused on how cases don't have a life on their own. They need people to legitimize those cases, make them known, and transform them into case law. Last question is the question of intervention and how we can see international criminal law as external intervention or not, or how do we relate it to processes that are domestically oriented. This argument has been waged over and over. It is particularly present in the context of the ICC, which is widely seen as a neo-colonial tool. It is widely used by other scholars, like Phil Clark. It's not something that you use, thankfully, I should say. But I think to understand this, to unpack this last box, it is essential, again, to bring history back in, to distance ourselves from the pathos of history and to look at the paths that history have drawn and how international criminal tribunals fit in them. I have too much to say, so I'll stop there.
Absolutely wonderful. We should have made this an entire conference rather than an evening. Our last speaker is Omer Shatz, a lawyer, Yale Law School grad, which is nice. And he, in Israel, his human rights law firm specialized in Supreme Court litigation of high-profile international and constitutional court matters, such as targeted killings in the West Bank, war crimes in Gaza, implementation of the Oslo Accords, etc. He also defended, was co-founded and was legal advisor to We Are Refugees that provided pro bono legal advice to hundreds of detained asylum seekers. In France, he was a senior associate at Sherman & Sterling, a well-known law firm, very prestigious here in Paris. He's provided legal advice to various organizations, Doctors Without Borders, and Julian Assange, so I learned something this evening. But most interesting, as a clinical project, he has initiated and directed the filing of a brief to the International Criminal Court concerning EU migration policies in Central Mediterranean and Libya. And he is involved also in the European Court of Human Rights case against Greece concerning the criminalization of a rescue NGO in the Eastern Mediterranean. So he's very active in these issues as we speak. I'm eager to hear what he has to say about Kerstin's book. So he's also, I should say, a lecturer at Sciences Po Paris, so right down the road. Please join me in welcoming Omer Shatz to AUP.
If I have a voice, I have a voice. Okay. So actually, while being it's okay. While being sick, I read Kerstin's book, and so I'm not sure about the insights, but actually there was one case before I will move to talk about the case that was just mentioned about EU migration policies in the Central Mediterranean, Libya, that is pending before the ICC. In the context of Kerstin's book, there was one case in her book that really, I can't really explain why, but the case of Velpka from Nuremberg. How can we tell it? How much time do I have? 10 minutes?
I think you have 10 minutes, yes.
10 minutes. Okay, so.
But you may have 15 if you
Yeah, we'll see. So how can we, in a nutshell, this case was about.
It's about Home for Children, right?
Yeah.
It's about a Home for Children,
Maybe
so it's a World War II era case. It's one of the few cases that's collected in this kind of book of great cases. Like, these are the cases we have from World War II. There were tons of trials, thousands of trials after World War II by the Allies. And we only have a few that have been gathered by the UN, like 8 volumes. And this is one of the cases that we find. And in it, it's basically assessing the guilt of a doctor and nurses who ran an internment camp for infants. So basically, Polish workers who had babies needed to go back and work. And if they were holding their babies or keeping their babies, then they couldn't be working in the fields. So the Nazi administrators set up a place to put the babies, and they had a lady run the place. And then they had doctors come and check the babies, and the babies died in droves, right? The babies died, and they died, and they died. and the mothers would try and come back, but they weren't allowed, and the person who ran the farm tried to let them go back, and then that wasn't allowed. And there was the administrator of the camp, so this was the question of the guilt of the various people involved in the running of this home for children. And what I talk about a lot in the book is, so there's certain, like the Nazi administrators, like, okay, those guys, not a problem. But then there's a bunch of Nazi administrators who aren't actually considered. We don't know much why. It's very, very short. So all the people who are left out, we don't know a lot about it. The woman who ran the camp, they said, well, she did the best she could, but she also went away for meals and stuff. So I think I can't remember what it was 15 years.
Yeah,
The
everyone
doctor-
were.
Yeah, there was a doctor who originally visited and then stopped visiting. And the court found both those things were problematic. He was part of the joint criminal enterprise of the camp while he was helping them by going to see the babies. And then when he stopped, because this is vile and I won't participate, he was also guilty.
Yeah, so I think this is a lawyer's trick. This is not part of my time, right? But they were all convicted, and the question that Kerstin raises, and Justice saw, is what could they do otherwise? I mean, the doctor was equally convicted for visiting the babies and for not visiting them, for example, right? And this reminded me, don't ask me why, of a nice dialogue between not an ICT and the Eichmann trial in Israel, in which not many know, but I mean, there are transcripts also from the police interrogation of the Eichmann trial. And in the police interrogation, not in court, Eichmann tells a really, I think, worthwhile to cite his encounter with a Jewish friend that was named, his name was Storfer. He was a colleague. They were used to work together. And somehow this dialogue echoed to me the three elements of Kerstin's theory about the non-derogation, and especially the two second level ones, the way we establish a historical narrative and the possibility of reconciliation. So maybe I would just read. So Storfer was a fonctionnaire in the pre-war era. The policy was just to make the Jews leave. And he was collaborating with Eichmann to facilitate this process. This was before during the war, when they started to set up the camps and everything. So essentially, Storfer was also immune from arrest by the Gestapo because he was working with the authorities. And then one day, Storfer is stopped by Gestapo, and he tries to run away. And he's getting arrested and sent to Auschwitz. And Hess, the commander of Auschwitz, tells Eichmann, your friend Storfer has arrived. And this is the dialogue. And maybe I'll say something afterwards. So this is from the police interrogation of Eichmann. So Eichmann says, I said to myself, okay, this man has always behaved well. That is worth my time. I'll go there myself and see what is the matter with him. And I go to Ebner. This is the chief of the Gestapo in Vienna. And Ebner says, I remember it only vaguely. If only he had not been so clumsy. He went into hiding and tried to escape. This relates to what I told you before, that if he had not escaped, he wouldn't have been detained and end up in Auschwitz. That's why he's clumsy. Something of the sort. And the police arrested him and sent him to the concentration camp. And according to the orders of the Reichsführer, Himmler, no one could get out once he was in. Nothing could be done. Neither Dr. Ebner, nor I, nor anybody else could do anything about it. I went to Auschwitz and asked Hess to see Storfer. Yes, yes, Hess said. He's in one of the labor gangs. With Storfer afterwards, it was normal and humane encounter. He told me all his grief and sorrow. I said, well, my dear Storfer, sorry, it's very important. Well, my dear old friend, we certainly got it. What a rotten luck. And I also said, look, I really cannot help you, because according to the orders from the Ratsführer, nobody can get out. I can't get you out. Dr. Ebner can't get you out. And then I asked him how he was. And he said, yes. He wondered if he couldn't be let off work. It was hard work. And then I said to Hess, work? Stauffer doesn't have to work. But Hess said, everyone works here. So I said, okay. I said, I'll make out a cheat to the effect that Stauffer has to keep the gravel path in order with a broom. It's not the version I know, but essentially he had to clean the pathway. And that he has the right to sit down with his broom on one of the benches. To Stauffer I said, will that be all right, Mr. Stauffer? Will that suit you? He was very pleased, and we shook hands. And then he was given the broom and sat down on his bench. It was a great inner joy to me that I could at least see the man with whom I had worked so many years, and that we could speak with each other. So this is, it continues, but this is the dialogue. And I think there is something about the unquestionable liability of Eichmann, but also about the question that also Velpka cases, in many cases, international criminal law arises, what a state agent that is abiding the law of his time, of his regime, can do to avoid criminal liability in hindsight, right? Eichmann is also a paradigmatic example for the principle of violation of the principle of legality, right, of the nullus crimen sine lege. He was judged by laws that were legislated after the acts, after the crimes that he committed, right? And this is a question that we keep asking, and I think Kerstin in her book provides some answers. And in relation to my case, to more contemporary example, I also found many strands that can explain why my case is not being investigated by the ICC, why my case probably will not be prosecuted by the ICC. And I think if we look at the ICTY, there are many also similar circumstances. For example, there is a tribunal that is already legitimized. The tribunal has a case pending on the situation in Libya that is already investigated. But for some reasons, the prosecutor, this court, focuses on the least responsible actors, on the Libyan smugglers, on the, and the question is why. And I think Kerstin in her book tried to provide an answer. I invite you to read. I can't summarize it with the time we have. But I was just contemplating about the case that is quite exceptional in the international criminal law jurisprudence, in the sense that normally we have the third element of reconciliation between warring groups, right? And typically, this can contribute to the enforcement of the progressive international criminal law and the accountability and to end impunity. But in this case, when we are dealing with a targeted population that is stripped of any political authority, right? There are what we call asylum seekers or immigrants or emigrants or immigrants or migrants or person in need of international protection. But as Aaron said, in this context, for any practical purposes, they are stateless. So if we look at all the international criminal tribunals from Nuremberg onwards, whether it was the tribunals of the victors' empires or like the ICTY ad hoc tribunal that was established by the UN, there was always issues of sovereignty, of reconciling between the Bosnian and the Serbs, or internally, whether it's non-international armed conflict or international armed conflict. And here we have a population that is targeted, and as we speak, it's an ongoing policy and crimes. It's a population that is purely civilian with no sovereignty, right? So this is maybe one reason why the ICC will not investigate and prosecute the most responsible actors. We need to finish. Second, maybe just one second point. Second point, I'm sorry, that I found really interesting is and in comparison between the theory of Kerstin and this case, is the fact that we are dealing with a case that is at least in part not related to an armed conflict. So it's in peace times. And it's not about war crimes, it's more about crimes against humanity, at least as long as we talk about the central Mediterranean. And to date, till now, most of the civil society organization and the stakeholders frame this situation that we don't understand why it is happening, why we are witnessing these tragedies every day of boats that are shipwrecked and of moms that are found dead with their children still embracing them, just recently yesterday in Lampedusa, etc. And we don't understand how come it's happening. And maybe one of the answers that is also is resonating in Kerstin's book is the framing of this as human rights law, what you call margin of appreciation, contextualization, saying, this is migration policy, it's a sovereign state prerogative, it's a maritime law, then we have to find a safer port elsewhere, it's human rights law, so non-refoulement, does it mean that it's... So what I'm trying to say is that this case is maybe the first case that is trying to argue that grave breaches of human rights law, such as the principle of customary human rights law, such as the principle of non-refoulement, the right to life, etc., may constitute international crimes, may constitute atrocious crime within the meaning of international criminal law, without the need to rely on international humanitarian law, war crimes, Geneva Convention, etc. And this is also something that I found very interesting in Kerstin's book. Thank you.